All right, guys. Thank you for joining us. It's the first Tuesday of the month. You know what that means. We're doing Startups in the Law with JonesKertz again. I believe this is the fifth time that we're doing this, which is awesome. We've had a lot of great response to this. Just so you guys are aware, JonesKertz, my law firm, is based out of Dallas, Texas. We help startups, entrepreneurs, founders, and investors do what they do best, which is help run and grow startups. And this entire webinar, the entire theme of it is really education. I mean, we are trying our best to help you succeed in a way that, I mean, quite frankly, here's what I should say. We're trying best to help lay the legal foundation for you and your businesses so that you don't so that you have a lower rate of failure and a higher success rate with what you're doing and can make money more quickly. So, and I'll talk about that in a minute as far as our mission goes. Right here, you can see our contact information. Matt Jones, our other partner, is based out of Oklahoma City. In Oklahoma and everywhere else with Texas, we go by the name Verge Law Group. But in Texas, we have to go by JonesKertz because of some weird naming issues with law firms. We're not allowed to go by a trade name, which is what Verge Law is. But anyways, if you have any questions during or after the program, please go ahead and give me or shoot me an email at kyle@joneskertz.com. And without further ado, I'm actually going to introduce our special guest for the day. Today we have Andrew Reed with Carstens and Cahoon. Tripp, do you want to go ahead and add Andrew into the panel? So, welcome. Thank you. Really appreciate you joining us today. So Andrew Reed and I met several months ago, probably a little later last year, actually. And I mean, Andrew is a patent and intellectual property attorney, and I mean, he works for basically exclusively an IP law firm, right?
Yes, we are an IP boutique, so we handle everything related to IP and anything regarding litigation related to IP and all that goes with that.
Yeah. So, as far as what you do, Andrew, can you describe a little more about what your focus is when it comes to patent law? I know you're primarily a patent attorney, but you sort of do some of the other stuff like trademarks and some other IP stuff, right?
So for me, I'm a patent attorney, so that means I can practice for the U.S. Patent and Trademark Office. So I also handle, besides patents, I handle trademark applications, anything necessary with trademarks such as cancellations, oppositions, copyright applications, even going to do trade secret audits, so helping people make sure they maintain their trade secrets in a way that they still maintain a trade secret status, then as well as doing litigation. So I'm lucky I actually get to split my time roughly 50-50 most of the time, where I do part of the time handle litigation, part of the time focus on everything else related to IP, which may be filing, dealing with transactional issues, licensing, audits, performing just general maintenance duties with IP.
Nice. So, and that brings up something that I wanted to talk about at the very beginning of this, to sort of describe the difference between what we do and what Carstens and Cahoon and IP law firms do. I mean, generally speaking, like people like myself who do not have technical backgrounds such as engineering degrees are not allowed to practice patent law. So I can practice practically every other form of law so long as I have the license to do so. But I'm really just not allowed to practice patent law because it really is such a specialty and such an expertise, and is so much narrower than a lot of other aspects of the law that we practice. So like the way I would describe myself compared to a patent attorney is I'm more of like a sort of a general startup law firm attorney. And so, I mean, I help start and grow businesses through different contracts, help draft agreements for people, potentially even help them sell their businesses when it comes time to exit. But I mean, and generally I have to at some point refer business out to someone like yourself which we do quite a bit of because we work with tech clients for the most part. So, and I think, and one of the topics we're going to address here in a little bit for our audience that's listening in is, I mean, if you're a tech startup or a tech company, at what time does it really make sense for you to go into the patent process, or even just assess whether or not that makes any sense for you? So, without further ado, though, I do want you guys to know, though, like, if you have any questions for Andrew, please take down his email, jareed@cclaw.com. He's pretty responsive and pretty quick on that, and would love to talk to you guys if you have any other questions after the show is over. Without further ado, I mean, here is a little bit of a description of our mission. I mean, the reality is better education when it comes to startups and when it comes to founders and when it comes to initially starting your business. I mean, in my opinion, like, it just leads to a better foundation and overall a higher success rate. You've heard that stat that says 9 out of 10 law firms fail, or not 9 out of 10 law firms, 9 out of 10 companies, I should say, that are new end up failing. And the reason for that, in my opinion, as a startup attorney, really has to do with a lack of at least just a basic understanding of what is going to be legally required of you and your business on an ongoing basis. I mean, it really spans the entire spectrum of whether when it comes to contracts, when it comes to just knowing at what point that you really can't help yourself any further and really should seek a professional like a lawyer or a CPA or some other sort of financial professional that could help you grow your business, or at least do it in a way that protects you from outside liability. So, I mean, that really is, this really is a part of our mission and why we do this. And we'll be doing this every single month for the foreseeable future, on the first Tuesday of every month. So stick with us, and I mean, we'll do something different every single first Tuesday of every month. But moving into what we're going to talk about today, patent law basics. So we're going to talk about really a higher level overview, what I would call the 30,000 foot overview. And then we're going to go into some of the more granular type of issues that that we deal with on a regular basis when it comes to patents. So when it comes to this, Andrew, like, this is all going to be Q&A style, by the way. So I'm going to be basically posing these questions to Andrew and talking through them with him. So, I mean, a lawyer like me practices like a certain aspect of intellectual property law. So I'm capable of doing trademarks on a regular basis. I mean, that really does fall within the wheelhouse of very many business lawyers. But really, I guess we need to understand what is the difference between other forms of IP and a patent. So trademarks versus patents, copyrights versus patents.
So patent really protects what your ideas, products, your innovation is. For example, it could be something related to a software program that is unique and novel that maybe helps a computer perform better than it has in the past. Maybe something as simple as a new way of building a chair. It may be something that is something you think different types of bags are patentable. There's also different types of patents. So you have the utility patent versus design patents. There's even plant patents. So there's different ways to protect different aspects of ideas, innovations, and the products and services that a company might offer. Now, along with that, you have trademarks, which protects the brand and anything that gives you the protection for. The good example of a trademark is the hang tag or the little slip tag in the back of a t-shirt that has the logo of the company, tells you who made it, where it came from. It's really a source identification. So that really ties in. One thing I like to always say is last year, Tiger Woods, when he won the Masters, when he had that Nike hat on, all of a sudden Nike's value spiked just because that brand, that logo that they had, that trademark. Mm-hmm. So yeah. That's it. And then you have copyrights, which also kind of overlap with both the patent world and the trademark world just slightly in that it protects the expression of maybe not an idea, but the physical manifestation of it. So it may be the pictures you take for your advertising, for example, or your logo put with a particular advertising flyer. Those are things that are for copyrights.
Yeah, and I think that what you said about, a copyright not applying to an idea, would you say that, a patent technically could apply to an idea so long as it's fleshed out, far enough and doesn't infringe on any other patents and will actually pass the application process?
It's one. So I'll make one correction. It's not that it would infringe on anybody else. It's yes, you can protect an idea as long as it's fully fleshed out in some way. And by fully fleshed out, it means you've conceptualized it in a way that when written down, someone else could take what you've written down and replicate your product or what's protected by your patent. That's the best way to describe it.
Okay.
And it's not that it would infringe on other patents. It's that it hasn't been, in order to get a patent, it has to have not been in the public or publicly described or disclosed before.
Okay. So it really does apply more to systems, processes, and developments and innovations in technology as well as products, right? We're looking at, how to build something and in many cases what the end product ends up being, right?
Correct.
Okay. And and with that, we're looking at, does what you've created innovate on someone else's creation, right? That's one key issue that I think some people they're unsure of. They're afraid, am I infringing on this other person's patent because I've come up with a better design? And
it's one of those, it's the favorite of every lawyer. And I know most clients and people that you talk to don't like it. It's honestly, it depends. But ultimately, if you're improving on somebody else's design or product that they have patented, there is a chance that you may be infringing on it. But that's where going to a patent attorney like myself, that allows that patent attorney to review what they have in. So a patent includes what we call claims, and claims are what is actually protected. So if their claims do not cover your improvements as well as their original design that you improved them on, then you wouldn't infringe on that patent. But that's where we also would want to do some searching to determine, well, what other patents do they have? Because they may have multiple patents on that product or design or system, whatever it may be.
Okay, and I think that's a good segue into our next slide. As far as the ultimate legal effect of obtaining a registered patent, something that is now discoverable, what kind of protection does that afford the people or the companies that own the patent itself? What are they allowed to do with it really? Aside from the obvious, which is like build something that they can call their own, right?
So what a patent protects, most people think it allows them to go make their invention. It actually isn't. It's more of a restrictive right. It allows you to prevent others from making, using, selling, or importing your protected invention.
Mm-hmm. So in other words, like if they wanted to go do that, they would have to license the patent from you in order to be able to do that. In other words, pay you a royalty or a fee for doing so.
Exactly.
That might look like. And so, as far as the legal effect goes, so in trademark law, whenever you obtain a registered trademark with the USPTO, you end up, like, I believe the phrase is, it puts everybody else on constructive notice that you own a trademark, whether that be a plain name or a trademark over the design or logo or symbol or something like that. Does constructive notice apply to patents as well?
Yes, it does. So once a patent, so there's actually 2 points where a patent will become public. 18 months after it's filed or its earliest what we call claim of priority, which, because you can file multiple patents, so you may actually be 5 or 10 years down the road when you ultimately file additional patents if you have pending applications. With an issued patent, it allows you to, 18 months afterwards, it is published after you file. And then also once it issues, it publishes again. So that once those two publications are out there, or either one of them actually, that puts people on constructive notice. And that initial publication can also be beneficial, especially to startups, because it can, especially if your claims are substantially similar to what is in the issued patent, that can allow you to start putting people on notice back to that particular date. And especially if you've told someone about it that may be infringing your patent, that can allow for some additional damage calculations as well.
Okay. So let's talk about publishing for a second. So, I mean, I think a lot of people, they're not really sure what publishing really is. What exactly is that? I mean, where is it published? I mean, what does publishing really mean? Because I think that's a bit of a, like, we talk about that in trademark law as well. But the problem is, I think everybody who's a lawyer understands it, but nobody who isn't a lawyer really gets it.
Yeah. So the USPTO puts out the printed published applications as well as the issued patents once a week. So usually the printed publications come out on Thursdays, patents come out on Tuesdays. That's how it's usually been historically. So they'll come out and they will be published through the, they'll come usually through, there'll be a notice put out in the USPTO Gazette, as well as then they'll be available through the USPTO's website. And they also are then sent to the Library of Congress, so there's a copy there as well.
Yeah.
And so they're available usually as soon as they're up on the USPTO website, anyone can download the full patent. And as soon as the patent, if you have a published application, then you're what they call the file wrapper. So any of the documents going back and forth between you as the applicant for the patent application and the U.S. Patent Office, that also becomes public. And that's to allow people to know, okay, what did you as the inventor or your representative, your attorney, say about another patent that may have been very similar, a printed publication that may be, for example, in a library, even a library somewhere overseas. That there's publications that can come into play as well.
Yeah. So, I mean, another general question I have is, how long does a patent last for? So we know that, I mean, a trademark conceivably could last forever so long as you continuously renewing it. And we know that a copyright actually does have, unless you create some sort of, unless you transform it in some way, I mean, the copyright does have an expiration date. I believe it's something like the life of the person plus 70 years who created it for some forms of copyrights. Others are a little bit different. But I mean, patents, I think, have their own set of expiration dates that are totally different as well.
So it's 20 days from the initial filing in terms of, and that initial filing also includes a claim of priority, like what I was explaining earlier. So the claim of priority, an example of that may be you may include in your patent, for example, claims that go for a widget that has elements A, B, and C. But also in your patent, you disclosed A, B, and D, as well as A, B, C, D. Well, your first patent may be on A, B, and C. So you can file a continuation before your patent for A, B, and C issues that claims priority to that original application. That allows you to then go in and claim in the A, B, C, D form of it as well. So you can have multiple inventions or multiple embodiments of an invention in a single application and get your claims directed to different aspects of it and continually file applications as long as you don't let them issue or abandon before you file the next one.
Okay. So do some people actually do that where, I mean, I can imagine a large place like Apple or IBM is probably continuously filing iterations and patents and but I mean, that's probably not feasible for a startup, right? I mean, we're talking about, I mean, we probably want to only patent like what is the most important thing about this, because they can't be doing that forever, and that would be, unless you've got endless amounts of money, prohibitively expensive.
Exactly. Well, there are ways to make sure that it is, for example, a little bit cheaper. One thing to consider is usually when you file an application, it takes anywhere from 24 to 36 months for it to be fully examined.
Yeah.
And then once it starts examining it, each round of examination goes in at usually 6-month intervals. So it can take sometimes, especially right now for software related patent inventions, it's anywhere from 3 to 5 years before there's any type of real determination whether it's going to issue or if the examination is going to have to go further. And there may be ways for it to go further, but that gets on a real long tangent, so I won't go there right now. But so a startup could effectively put a lot of details and potentially a lot of different embodiments in their initial application. And maybe they don't file for all those, but they let that process keep going further out. And then, for example, 3 or 4 years down the road, hopefully they've made quite a bit of money from their invention starting out. And then they can file that continuation and keep building on that, the claims around that invention and that patent application that they already have. So they can create, for example, a picket fence around their idea so that they protect not only their core invention, their core idea, but also make sure that they've got everything, or try to get as much around it as well, so that a competitor can't come in and get that one little piece, that maybe that one idea that is just a really great idea on top of theirs.
Mm-hmm. And I do have some other questions probably toward the end of the presentation about, I mean, when it comes to protecting, I mean, how exactly does that work? How do you even find out? But I want to hold that toward the end, because I have questions about patent trolls and people like that, and potential litigation that comes with filing a patent, or at least having somebody intervene, I guess you could say, on an application. But I mean, as far as the definitive examples of things you can patent, I mean, as it applies to technology startups, I mean, software as a service businesses, I mean, whether that be B2B, B2C, what exactly does that look like for a lot of startups that you see? So
it can, historically, what a lot of the courts have usually said is it can be anything under the sun that is not a phenomenon of nature. So you can't, for example, patent the force of gravity. I mean, that's just an act of nature that can't be done. And you can't patent a abstract idea. And a good example that I like to use of an abstract idea is, you can't say, I've got this software for bookkeeping. It does it exactly the same way that CPA will do bookkeeping with pen and paper all day long. I'm just applying it to a computer. That is going to be an abstract idea. Okay. So recently there's been a lot of disputes. There was a Supreme Court case back in 2014 about what constituted an abstract idea. Courts and patent applicants have been fighting that out with the USPTO and the court system for the years in between, and still currently fighting it out. But we're starting to get some more definitive answers on that. So software is actually something that still can be patented. Really what we look for is there a technical tie-in to some type of hardware where it can either make improvements? Is it a really structured application or software method that improves upon something that's already out there? And we can try to make that improvement as clear as possible, and try to show that it's not just an incremental improvement, but actually a jump in improvement.
Okay. And that was something that I was always concerned about when I had clients that would come to us and say, I want to patent the software that we've created, because whenever they come to us, they're always iterating it, right? You always have to keep updating it. And especially in the case of mobile applications, I mean, the updates are not just a matter of progress for your business, improving functionality. It really is driven by enhancements in iOS as well as Android operating systems. Mm-hmm. Those are baked in, and basically have to innovate it at some point and adjust it based on these operating systems. And so, I mean, so it really has to be like, is the core of what you've created software wise a leap forward as far as whatever that technology was before and what it is now, like based on how I understand it.
Yeah, and it's really you're trying to, yes, in a summary, we are looking for that leap forward when trying to do those patents. But there are also ways to help protect it, in particular especially with software that is just coming online, or where a company is creating something new, and they may still be trying to figure out what steps they're going to take to completely solve the problem. There are some ways that different types of patent applications that can be utilized to put it in process, but not necessarily. We can wait, for example, with an example of it would be provisional patents. We can file several provisional patents on those incremental improvements, and then make sure we file the non-provisional before the first one will be expiring, and gather all those up and put that in one application. That way we can keep up with those incremental progress steps without just jumping on the next thing, and being able to make sure that we capture everything. And then if something doesn't work out and they determine that's not going to be something viable with either the iOS or Android, whatever it may be, we can toss that piece out and then keep adding on the new parts without necessarily throwing away the whole patent application.
Yeah. And I mean, when it comes to like the patent application process, I do want to expound upon the provisional versus like the actual registration of it. I think when we talked the first time about patents and the differences between a provisional and a traditional patent application for registration, I mean, you had mentioned that like the provisional really does help you at least preserve your rights. And there is a specific window of time here that really does matter, from the moment you go public with the I guess the innovative idea or the new technology that you've created, and that there's an expiration date on the amount of time that you have to be able to file.
There is.
So, and let's talk about that. So how long, like, let's say I publish on my website that I've got this brand new technology, and I've got something that fundamentally describes it. It's not exactly demoing it or anything like that. Or maybe I do have some wireframes up of what my application looks like, but I mean, I'm not sitting there showing you a video of it or anything. I mean, does that start the clock as far as what you have to do?
It will depend, but most likely it will start the clock for what is disclosed.
Okay.
It won't necessarily start the clock if you have underlying systems and methods, processes that do what you're saying there that are novel, that aren't fully described. Those would most likely be improvements upon what was publicly disclosed. You in the best of all worlds, you would file a patent application of either a non-provisional or provisional patent before you actually go public. Because once you go public, there then becomes an issue of, well, did you publicly disclose everything? Is it within what we call the grace period in the US? And really then it also comes into play if you're going overseas. A lot of countries in Europe don't actually have a grace period. So if you publicly disclosed it before you file the patent application, you're actually kind of out of luck. It wouldn't be enforceable in those countries. So that's something that has to be weighed at the time of filing to kind of determine what type of patent application, how the different ways and avenues that the patent process could take.
Okay. And I do want to talk about that for a second. So, I mean, let's talk about the instance with a lot of startups where, I mean, they're pitching their ideas to investors. They're pitching their ideas to maybe their friends and family to just sort of gauge interest. Does that constitute disclosure that would require starting a patent application or at least a provisional?
It can in some respects. especially if it's not done under an NDA of any kind. If there's no type of respect to confidentiality, then most likely it would be considered that a public disclosure. Posting it on a website and then saying, hey, go check this out, in particular, that's a public disclosure. If you're putting it up, sharing it with a large group of friends and family saying, hey, check out this, would you be interested in investing in it? Without saying, oh, by the way, keep this confidential or anything like that, that's probably running the risk.
Mm-hmm. So yeah, and for those listening right now, like you've probably, if you've ever been in front of investors or anything like that, or if you've ever talked to anybody about raising venture capital or any other sort of investment, you've probably heard that investors are extremely averse to signing non-disclosure agreements, mainly because a lot of non-disclosure agreements also contain non-compete language. They simply don't want to read it all the way through and don't want to be bound by anything like that because, well, I mean, they want to be able to talk to other people who could potentially invest in those businesses. A lot of reasons why they don't sign it, but those are the primary ones. And so, like, I guess that presents a sort of catch-22 situation for those people who are interested in obtaining a patent, but have to talk about their idea in order to make it a reality. Because, I mean, it's sort of a chicken and the egg situation. I mean, if I have to get money in order to obtain a patent, but I have to talk about it in order to obtain the money, I mean, what do I do first? And I think a lot of people are, I mean, for those of you who are sitting there thinking, well, I have to have a non-disclosure agreement right now, I'm not sure that's necessarily the case, but maybe you could just self-fund a provisional application to get that process started and then use that as just a 5 to 10 second talking point in your pitch to investors. That way they understand that, hey, we are trying to at least obtain protection for this. That way we're preserving the IP, creating more value than is otherwise there, right? I think that is a really important point when it comes to patent law that it is overlooked on a regular basis.
There is one way that they can. It's not a preferred method. I will say I really don't like doing it, but we've had to do it for some applicants in the past. Is we will go in and they're going to, for example, do a presentation. We'll take that presentation, put a cover letter on it, review it real quick, see if we can add anything to it about the disclosure, and then file it as a provisional patent application before they go disclose it. Because that way, at least what they are presenting can be protected. Now, if they say something beyond what's in the text, then there can be some issues, but it's one, it at least gives you something. So it's one, especially in the case of an inventor going to investors that don't want to sign an NDA of any kind. Make sure they can do a provisional patent application, even if it's just that presentation. Like I said, it's not the preferred method, but it's better than doing nothing at all and risking losing everything because you don't have a non-disclosure and making it publicly available and forgetting about it with past that grace period and then realizing, oh, yeah, I did that, and then making it where your patent effectively is worthless because you can't enforce it anywhere.
Yeah. So I think we've already talked about this point that's on the slide right here. Let's go on to the next one. So this question is actually probably one of the more important questions that I think, before I started talking to patent attorneys on a regular basis and asking them like what the general consensus was on who to go to, like what this stuff costs, like, et cetera, et cetera. I mean, when it comes to a patent attorney, like it almost always helps to have somebody who is specialized in the area in which you are patenting. So mechanical processes, for example, are probably more appropriate for somebody with a mechanical engineering background and for somebody who does mechanical process patent applications on a regular basis, right? And
yes, and it's one yes and no. Different types of engineering have a little bit different bases. So, for example, me, I have an electrical engineering background, but I also was doing a lot of hardware in terms of major power systems related, to example, for transformers, what we call grid technologies relating to how power gets from a generator to your house, dealing with that type of stuff. So I had a lot of mechanical knowledge because of working in that field. So a lot of what I do is related to mechanical, electrical-based systems, but it doesn't mean I can't go beyond that a little bit. So a general patent attorney can definitely help you get a patent, but when you start getting into the specialized details, sometimes it definitely does help to have a specialist on board. So like our firm, we have chemical engineers. We have a couple of people, if I remember correctly, they're physics majors, several that are mechanical engineers, several electrical engineers. So we have a wide variety of backgrounds, and that also gives us an advantage so that all of us can write the basics of the patent application and a lot of what the general language and describe each invention in usually the general ways, but maybe we do need some expertise on certain points of it. So we might pull in somebody that, for example, one of our attorneys has background in aviation. If I'm writing an application that deals with aviation, something in aviation, but it's also electrical that I'm used to drafting, I'm probably going to go to him and have him review portions of it, maybe add additional details to help beef that patent application up on those aspects of aviation.
Okay. Yeah. And so, I mean, you work together with a lot of other people to make sure that, I mean, the patent application is well-rounded and couched with the experience of those other professionals, which I think really is the difference between somebody who might run a solo like patent practice. You're talking to somebody who is probably trying to do it all if they can't really specialize in their particular area that they've been practicing in. And so, I mean, and I've heard from other attorneys who give feedback and they'll say, well, because this person did not practice this particular type of patent law, I mean, they missed out on approximately 5 years worth of law in the area. And that's reflected in the patent application, which I think a common misconception, like with some patent applications, is you could potentially obtain a patent that really is no good. Like in some cases, if the research hasn't been done properly and the case law really hasn't been read on why that patent didn't obtain or why that patent infringed on another patent or something like that, or didn't meet the criteria. So I think. Yeah, and the one case that I'm referring to was from another patent attorney I was discussing this with, who he said that you could just look at some of this stuff and realize it's just totally inadequate. I mean, it doesn't even get there, but somehow obtained a registration number or something like that.
Yep, it happens, and part of that is because the way the laws are interpreted might change. Like we were saying, that a patent application can go for 20 years from that initial filing. So it's one, you may have a patent application that's been pending for 5 years and issues, and then a year later, the Supreme Court may decide, well, yeah, but everybody was interpreting that part of the statute wrong. Here's how it should be properly interpreted. And then unfortunately, your claims may not be adequate at that time, which hopefully at that time, you still have a patent application pending before the patent office, and your patent attorney can go in and change the claims. Hopefully everything within this, what we call the specification, all the description of the invention, the drawings, can support additional claims that would be interpreted as the Supreme Court or one of the appeals courts has said, this is how it should actually be interpreted.
Mm-hmm. And so I think the overall point here is, I mean, make sure whenever you're choosing the professional to help you with this, that, you interview them properly and make sure they actually do understand, what you're trying to obtain as far as the patent goes. And that they at least have, like, don't just like sort of indirectly touch that area, but actually do that on a regular basis.
Yeah.
So
another good point to that is it helps, like, our firm, we do both litigation and what we call prosecution, which is the drafting and filing and arguing with the Patent and Trademark Office.
Yeah.
So that's our firm handles both. So it helps us because the litigation side, like what I do, I get to split 50-50. So I get to see both sides and see changes in the law, changes in how things are done, and how that could affect things down the road, and how it can change things for things that we're just getting ready to start. Mm-hmm. So that gives them the benefit of being able to see things coming and be proactive about it to make sure that we don't get caught in that situation where a patent application may later down the road, because of how a court determines something, make sure we don't get caught that way.
Mm-hmm. Yeah. And I mean, I guess when it comes to developing the materials to obtain the patent, I mean, I've talked with you about this, and this is also probably one of the most important points of the webinar today. I mean, when a person comes to you, or decides that they want to file for a patent, what stage of development should that new product or technology system process be in prior to filing or registering?
So it's one, I will say in some respects, it's kind of a catch-22, because again, you don't want to have a public disclosure on it.
Yeah.
But the more developed it is, the better your patent application can be, because usually you have more write-ups on it. And I'm saying you as an inventor, so using that as a description. So the invention is really fleshed out. You have good examples, maybe good pictures, good drawings, maybe some mechanical drawings of it already. Those can be very beneficial, because that's less that has to be done by your patent attorney to get ready for the patent application. Mm-hmm. And get it in a good process, good point for filing that application.
Yeah, and so I mean, the major point is, I mean, it really does need to be far enough along to where, I mean, it's mostly complete for the most part, and really we don't want the lawyer helping you to have to engineer it much further, because the issue is obviously, okay, I'm basically I mean, sometimes you're basically just iterating their technology in order to make sure that it obtains a patent, right?
Mm-hmm. And that's where it becomes more costly, and for the ones applying for it. Now, on the flip side of that, if you have when you're providing a lot of good examples, it's really fleshed out, the product's really close to being ready to go to market, it also helps because your patent attorney, yes, can still do a little bit of effectively kind of that engineering aspect of trying to put a little more into the disclosure of potential alternatives. And that also helps potentially prevent a competitor from obtaining a patent on a different, slightly variation on what your product is.
Which some people do. They'll hound those publications and try to see, okay, yeah, this actually is pretty cool. I think I could take this a step further and obtain another patent for it, mm-hmm. Or something like that, because it's what they're looking at is, well, this is the logical next step. This is clearly where this is going. I might as well just go obtain this because they're going to at some point in the future, right?
Yep.
And
that's where you can do competitive intelligence and find out kind of where your potential competitors are going. Kind of be strategic with your intellectual property strategy and make sure that you're finding out who your competitors are, what are they doing, and are there ways that you can effectively put a fence around their product where they can't expand on it. Mm-hmm. Maybe you see they've got, going back to the ABC type example, maybe they've got a patent on A, B, and C, but you can see, in just a year, we'll probably have D ready, and D can completely replace and be 10 times better, and it's a huge improvement over C. So let's make sure we get a patent on A, B, and D before they do.
Yeah.
Things like that.
Yeah, and I think that is one of the more important things to know here. I mean, it doesn't need to just be what it is right now. It really does need to look forward into the future as to where's the technology likely to go. I mean, if you had all the money in the world, so to speak, and you could develop this much further, I mean, what would it potentially look like? And I know that in some cases, for a lot of people who are starting businesses, that's you do a lot of dreaming, but it's not necessarily putting that down on paper in terms of that design, and then actually trying to register a patent and obtain the IP for it. But I think that's something that a lot of startups should be keeping in mind whenever they're developing new technology. The people are like the moment you start making a lot of money on something is the moment people around you are going to take notice and look at what about what they're doing could I obtain a patent for, or at least what about what they're doing is about to go to the next level that I could obtain that patent for. So, and I think we've already talked about, I mean, what the difference is between a provisional versus a traditional application. So I'm not sure we need to go into that much further. Did you have anything else you wanted to say?
Yeah, there's a couple things. So provisional patents and regular non-provisional patent application, there are some times when it may not be the best thing. Mm-hmm. For example, a design patent can't really claim priority back to a provisional patent because a design patent can't have a provisional patent.
Yeah.
So there's sometimes that a provisional patent might not be possible or might not be in the best strategy going forward. So it's always a good idea to sit down with a patent attorney and determine what's your end goal with your product and design or your invention. Maybe it's like I said, a service, a process, a method, and figure out what those best steps are. Because, like I said, with the software example, where software changes day by day sometimes, provisional patents can be very beneficial because you can catch those incremental changes and then take all the good stuff, throw away the bad, and get what you can get.
Sure. Yeah, and I mean, I think, one of the questions I think a lot of people do have, I mean, for a lot of startups, they will eventually obtain a trademark, and so, and usually there's a bit of a shock factor to hearing, well, that can take about a year. In some cases, in most cases, actually, in some cases it can take longer because people will intervene on your patent application. People will, I mean, the office actions that go back and forth between you and the USPTO, can extend the amount of time that it takes to obtain that. And mm-hmm. So, just similar to trademarks, but probably even more extreme is whenever you start this process, you really got to want it. I mean, it really is like. I mean, you have to want to invest 2 to 5 years, into this process because, I mean, just in your opinion, is it probably going to take a minimum of 2 years, once you've started?
Yes, I will say, short answer is yes. It depends on kind of how the process goes, what the different steps are. For example, a design patent, right now I'm usually seeing those come back in about 12 to 18 months. So 1 year process.
And that's just an initial review by the USPTO's attorney that is sort of that is doing the due diligence on that and mm-hmm. putting together any issues, any responses to whatever your application had that might have been deficient, right?
Exactly. And so since provisional patents aren't examined, so if you go the provisional route, that usually adds roughly a year to that. So if you file a provisional patent, non-provisional is usually you have to file it within 1 year of that provisional patent. So then that's adding a year. Then it's usually 18 months to 36 months, usually 18 months to 24 months before an examiner will pick up that application for review. Mm-hmm. They may have it for a couple of months before they issue or send any type of office action, notice of allowance. So I will say 95% of patent applications will get rejected. So 95% of the time you will get an office action of some kind.
Okay.
But hopefully it says somewhere in there is that one of the claims is found to have allowable subject matter. That's what our goal usually is to have one of the claims in it, whether it be what we call an independent claim or dependent claim. And basically, an independent is the broadest claim. Dependents are additions to the independent claims.
Okay.
We may have independent claim may go A, B, and C. The dependent may go A, B, C, and D.
Okay.
Good way to describe it. So it really just depends. Once you get that, it can be, what I would say is usually that it's 24 to 36 months before it you really know whether going to issue as an actual issued patent, or if it's going to be one of those it's just too much of a battle and maybe you do have to abandon it.
Okay. And I mean, when it comes to abandoning a patent application, what exactly does that look like? Are you usually providing notice to the USPTO that, hey, we no longer want this, or is it just it's going to time out? Your opportunity to pursue it further will expire under the law.
So it will expire under the law. So if you don't respond to an office action within 6 months, then it's deemed abandoned by the patent office. Now, there are ways that, for example, I have seen some case law where someone never received notice that there was an office action on their application.
Okay.
It can happen. It's very rare, but it can happen. So they can petition off, say this was never received. Inadvertently, we didn't know about it. Please let us respond. Patent office will decide whether to let that happen, or they'll say, nope, it's abandoned. You're out of luck. So, I mean, there are ways to revive a patent application if it goes abandoned, but you really don't typically happen in any case that it's usually done. And it's one, like I said, it usually will go abandoned by timing out, expiring. Now, there is some cases where you want to actually put notice that you're abandoning the patent application. Maybe you've got another one that continuation that we talked about a little bit earlier. Maybe you file the continuation, you're going to abandon the first one. You file the continuation, you say, this has been abandoned.
Yeah.
But a lot of times you don't do that. You just let time out.
Yeah.
It's the easiest way to do it.
And that's what I figured. I mean, it's fairly similar to trademarks. I mean, if you don't really want it anymore, it's not a matter of making any more movement on it. I mean, it's just a matter of letting that 6 month period come and go, or whatever the statutory period is, for continuing the filing, or at least trying to advance it. And so, I mean, you don't. I mean, once you start the process, there is a way to end it. I mean, logically speaking. So and I mean, as far as we talked about this a little bit earlier. I mean, but when it comes to, I guess, interventions by other companies that might have patents, interventions by companies that have other technology and things like that, some people are concerned about patent trolls. I mean, for obvious reason. I mean, these people make all of their money by suing other people, and that's and being sued, for those of you who might have been through that process already, is it's a very emotional experience. It's not fun, and it costs a lot of money. And I mean, to give you an idea, some large corporations, they might look like companies on the outside, but in many cases they are operating their own subsidiaries that operate as patent trolls. For instance, I think, not to talk bad about IBM, but I think IBM actually does have a pretty large organization dedicated just to pursuing their own patents, as well as enforcing them, which basically means you're never going to win a case against them because they'll go scorched earth. But the reality though is what's the actual danger? Whenever you're trying to obtain a patent for, say, a smaller business or a startup company that is trying to patent its software or hardware, how do you sort of avoid that situation altogether? Or if you can't avoid it altogether, I mean, what does the response look like to a patent troll intervention? I guess, so to speak.
Yeah. So the way they would intervene in the patent world is, while your application is pending, waiting for examination, or during the examination process, they might send prior art. And by prior art, that could be a patent application, any type of published material. It may be somebody's thesis from university, college. It could be anything, a website, anything that's out there that is publicly available in the public domain. They may grab that. There's a way for them to submit that before the examiner saying, I don't believe these claims are allowable over this art. And here, basically lay out, here's where it's shown, part 1, part 2, part 3.
Mm-hmm.
So that's how they would intervene while it's being examined. Now, if you are already selling your product, they may still come sue you. So using the patent process, that might be a way for them to discover, hey, there's somebody out there that is doing something similar. Let's go investigate them. Mm-hmm. So unfortunately, there's no way to really prevent that. Now, one way that companies can be a little more diligent about it is we can do prior art searches for, and there's different levels of those. It may be a simple knockout search where we're looking to see if there's anything exactly like what you're trying to patent. We may do a landscape study where we just gather everything that we can find real quickly, do a quick examination of it, kind of giving you a ballpark of here's how most of these claims lay out. Here are some avenues where some white space where you would potentially be able to get a patent application in. If you want to do that, we probably need to investigate further in those areas for you. And that probably leads to what we call freedom to operate search, where it's really in-depth looking at trying to look at any potential patent that might be of reference that a company could use to sue your company for making, selling, using, or importing that product.
Mm-hmm. Yeah. So, I mean, as far as the intervention process goes, or when it comes to suing, like normally these people are going to send you a demand letter, like a cease and desist initially. Mm-hmm. I think what is mysterious to most people is in many states, or at least before you take a case before a federal court, there is some sort of requirement to at least speak to the other side and gauge their interest in resolving the issue outside of court prior to bringing a case against you. Though I think some people, they might argue that they just bring a case in federal court against you for infringement or something like that, or for equitable relief, basically to stop you from manufacturing, stop you from using, stop mm-hmm. you from doing whatever it is that they are claiming is causing them harm. And they sort of bypass that process, right? I mean, they might just issue you a summons or something like that. Or send you a subpoena or something like that. I mean, is it like, do you see it often that, I mean, they just go directly to court, like, and try to get that, or no?
It's one I've seen it done both ways. I'll be honest, I've done it both ways. Representing a plaintiff before. It's one. It really just depends. It all comes down to what the client wants to do, because with the patents, there is no requirement that you absolutely have to send a cease and desist letter. Okay. It definitely helps, because that can trigger what we call willful infringement if they are aware of the patent and continue to go infringe that patent if it actually is infringed. Caveat there. It's one.
Claim for damages in the future because they now know, right?
Exactly. Willful infringement, because that can potentially lead to triple the damages award, so that can start to play. And it's one. It also depends if you're really just trying to get them to take a license. It's mm-hmm. one that just really depends what a client wants to do. And if they're receiving that cease and desist letter, there are different ways to handle that. And it really kind of depends what the budget is to handle that, because you get a cease and desist letter. One option is there's what we call inter partes review. So an inter partes review effectively allows us we would do a prior art search, see if we can find any prior art that we believed would invalidate that patent. And then you go to the patent offices and say, this patent should never have issued. Here's why.
Yeah.
And lay it all before them and lay that prior art. And then the patent owner gets to respond, and you go back and forth at that point.
Yeah.
And the patent office has a trial and appeal board within the patent office that makes that decision whether that patent should have ever issued in the first place.
And is that process more like more like arbitration, or is it actually, or is it more like an in-court experience, like the trial and appeal board?
I would say it's kind of a hybrid.
Okay.
So it's one, it's very heavy on what we call the briefing. So a lot of the written materials, putting that before the patent office. But there is a option for an oral trial. So you can still have an oral trial.
Okay.
Granted, it is very limited in terms of the witnesses provided, who can testify, things of that nature. So it doesn't go as far as a trial, but it is definitely a little bit beyond what arbitration is.
Okay. And so, let's say you go through that process, or it appears we have a question in the chat. Trey, do you want to throw that up for us? This is an interesting question. Andrew, I think we talked about this the other day. There are some people who are looking into, creating businesses that fund patent applications. I'm not sure if those exist at the moment yet. You might have a little more insight into that.
Yeah, there are some that are trying to create that so that they can get more funding. I know someone that's in the baking world that is trying to really work, kind of creating a system within their bank and working with his bosses of a way of evaluating and seeing what they can do kind of as a pre-small business loan to help people fund their patent application, and then be able to then get, for example, an SBA loan or a small business loan through that bank, through the Small Business Administration, something along those lines, so that they can later fund that and be able to pay it back real easily, but be able to do that pre-step, and so that they don't have to worry about the public disclosures, things like that. The other thing that can come into play is that one way to really reduce the fees that you will have to pay to a patent attorney to prepare the patent application is to go through, write as much of it yourself, put down as much on paper, get as many drawings as possible. Get that done, as much done yourself, because that's less, as Kyle was saying earlier, it's less that your patent attorney has to engineer, help create for you. It's already on paper somewhere. Yes, we may do some editing to make it where it's more in what some would say the legalese of a patent application. Make sure that we're not limiting or going too broad for you. But the more that an inventor can put into preparing and giving materials before a patent application disclosure is sent to a patent attorney, the better off they're going to be, and the cheaper that and the more, or the less time that patent attorney is going to have to be putting into the actual preparation time.
Yeah, and I think the important difference between what you're saying and what we call self-help by clients is try to focus on making sure that the design is as far as you can get it prior to the application. Yes, you could do research yourself. Yes, you can rely on all the resources. There's nothing prohibiting you from doing that. But at the same time, I would caution people on trying to use self-help in the form of filing the provisional themselves without the assistance. This is it's not just specialist work. It's also just, you don't want to shoot yourself in the foot at any point. You want to make sure that the first attempt at this was done the right way, not the wrong way.
Exactly.
As far as funding options go, here's what I would say. With respect to startups, we have some clients who, what they do is, when it comes to the friends and family round, or when it comes to raising smaller amounts of money early on, they figure out how much will it really cost for me to get there, or get part of the way there and start that process. While you might not have true funding in the form of $250,000 seed round or something like that, there is a way to go out there and obtain funding. You can, it sucks to say that you could put it down on a credit card. I don't really recommend that. What I do recommend is that you self-fund as far as you can.
Mhm.
The alternative though would be, I mean, there are some lawyers that I know of that will take, in some cases, like an interest in businesses in exchange for legal services. I would be cautious about entering into those relationships, as it creates a pretty clear conflict of interest between the company itself, you as the founder, as well as the attorney who's helping you, when you make that person a shareholder or a member of your business, or a pseudo investor, I should say. And so there are certain lawyers who will propose that to you. Um, I would I would watch out for that and make sure that any arrangement that you have with them allows you to walk away at any point. It's not. I think a lot of people, when they're first starting businesses, they like to bargain with their equity more readily, and because they think, I mean, this could be worth 100 million someday. I mean, why not get in on the ground floor? The reality is, like, I'll tell you, 10 times out of 10, always better to pay your lawyer in cash, because that way you can fire that person without having to think twice about it. I mean, when you have that person on your cap table, that becomes a little more difficult. Unless you have some sort of restrictive term allowing for unilateral repurchase of that person's interest in your company. So, aside from that, though, I mean, smaller banks actually would be a good source to go to. They might actually, like, if you have a relationship with local bankers and small banks, you can go and obtain a loan probably more readily than you could obtain one from Bank of America or Wells Fargo or any of the major institutions that I would call sort of like the big four banks. I mean, Chase Bank, Citibank, I mean, Wells Fargo, and Bank of America. I mean, and so I would just, I mean, keep in mind there are options open to you. And I mean, whenever you're talking to investors about what you're doing with the money, if they're asking, tell them we're using it to get a patent, which will allow us to take on further investment. I mean, I always, like, I coach people that, like, your investors do want to hear that they are taking on, like, that they're investing in something that is going to have some sort of moat around it as far as the IP goes. And so, probably not the answer you were looking for the person who asked, but if you have any other questions, I'd be happy to sit down and talk to you about it sometime soon. As far as monetizing patents, I think obviously patent trolls are experts at that, right? They sort of have a unique business of their own when it comes to that. But when it comes to the people who own patents, like the businesses themselves, like a startup company, I mean, the easiest way to monetize a patent is obviously to sell the products or to sell the services that have the patent incorporated into whatever they're selling. I mean, so subscription-based models. I mean, if you're doing a hard product or hardware, I mean, obviously you're selling by units usually, but there are agreements you can sign. So, I mean, let's say somebody had a competing patent or something that looked really similar to yours and probably does, I mean, sort of have elements that are the same. I know in trademarks, you can do one of two things. It's either a license agreement or a coexistence agreement. I'm curious, I mean, like, do you ever deal in those when it comes to patents? And I mean, which are more common? I mean, what's the market rate for a license, and what are some of the more important terms of those agreements?
So yeah, it's one, you can license it. You can, if there's somebody infringing, you can go and sue that infringer.
Mm-hmm.
So it's one, it really just depends. Now, licensing agreements, it really depends by what type of industry. For example, pharmaceuticals, medical devices, those are typically going to, and high-end software, that's going to be towards the higher end of the licensing spectrum. Something that's more general could be in more of a hardware product that is for everyday use. That's more, well, don't want to use the term, but I think the easiest way is more of a simpler type of patented product. It's probably going to be a little bit lower on that licensing scale.
Yeah.
Usually that's going to be some type of either lump sum or an ongoing royalty, depending on the amount of sales. So it really just depends. And then litigation, it all depends on what a jury says.
Yeah. And when it comes to like royalties versus lump sums, I think obviously the person who is selling a license probably wants a royalty. Like the person who is purchasing the license probably would rather pay a lump sum if they could afford to, but oftentimes they just agree to the royalty because, well, the economics, like I don't have $250K laying around to just buy a license for a term of years for this. So I guess I just have to pay a per unit basis, a per subscription basis, like sort of thing for whatever we're doing. And so more often than not, it is going to be just a royalty when it comes to monetizing these sorts of things.
Yeah.
You might pay a little bit up front, but and then I think some of the other more important terms are that I've seen, at least when it comes to trademark licensing agreements, which I mean, might be fairly similar to this. You probably have some sort of obligation by one party to another to indemnify you, basically protect you from any sort of litigation and outside claims that are a matter of you doing business with that patent, right?
Yeah. And a lot of that will depend. You'll see a lot of terms like that. Those come into play, particularly with whether the licensing agreement is going to be an exclusive agreement, i.e. between just two companies, or if it's going to be non-exclusive where the patent owner can go license to a large number of companies.
Yeah. And obviously exclusivity, some people are comfortable with that, but I think a lot of people, especially the people who are selling licenses to patented products or patents themselves, they probably are on the side of non-exclusive terms only because they don't, if the deal ends up not working out for you and you don't end up producing, then they probably want to, they probably want to go shop it with somebody else. And we're sort of getting into the weeds and getting outside the scope of what the purpose of this webinar is. But the general point here is there are a lot of different ways you can cut and draft the terms of these agreements.
Yes.
A lot of different preferences based on the industries themselves and the subsectors within those industries. And so no one size fits all. While we're saying like, yes, royalties very, very common versus lump sum payments. I want to make sure that everyone's aware, like that doesn't necessarily mean that is a fit for you if that's what you're doing. All of this has to be countenanced by the advice of somebody who's helping you draft the agreement, and you definitely want an attorney to do that for you because as far as the self-help goes, like we talked about, I've seen my fair share of really bad IP assignment agreements and really bad IP license agreements. And you want to stay away from doing that yourself, especially when there's royalties at stake. Because there are people who know a lot more than you do, and they will take you to task, and you won't even know it.
Exactly.
Yeah. This is an issue that has come up recently for us. We've been getting a lot of restructuring inquiries related to IP, and this is a very good question, I think, for you as far as initial structuring goes for a business and then ongoing structuring for a business. So, let's say a company that starts out as a Delaware corporation, it ends up inventing its own hardware and its own software. And it owns that. It even has a couple patents, one of each maybe. And at some point, does it make sense to break it out into other companies, or should we just keep it as one? Because I mean, is there any additional protection to, say, having two separate LLCs underneath that corporation? One with a hardware, one with a software, like one with the patents, one without, or maybe one off to the side with the patents alone, just on their own. And then you basically do an intercompany license agreement for all of those sorts of things. I mean, does that make sense, or is that just a really cumbersome way of structuring your business?
I have seen it always. I will say that. Realistically, I know some companies use their IP in terms of and restructure things for tax purposes. There are some ways that it can affect their bottom line in terms of taxes and revenues, etc. Sometimes, effectively, if they're trying to do a lot of licensing agreements, it may be worthwhile to put that IP in a separate company so that it's just the license agreement is with that company that's holding the IP. But really what, especially with some case law that came out in the past few years, is it can affect where you can be sued for patent infringement. So if a patent owner is going to come sue you for patent infringement, they've got to sue you where you have where you're incorporated or where your place of business is.
Yeah.
So your brick and mortar stores. One example of that is the Eastern District of Texas out in Marshall, Texas used to be the hotbed for where patent litigation was. Mm-hmm. Well, Apple decided they were tired of getting sued, so they pulled every one of their stores out of the Eastern District of Texas to make sure that they weren't necessarily getting sued or try to prevent being sued out there. There's some reasons why there's some case law that goes back and forth whether they can, and they're litigating that right now. So we'll see where that final outcome comes. But it really, because of that, you can be sued where you're incorporated. That can really play into effect for a startup because you don't necessarily want to go incorporate in Delaware if everything's going to be done in Texas. Because then you basically open yourself up to two locations that you can be sued real easily. So then it's like, okay, do I really want to go fight the case up in Delaware or have to fight to try and move it to Texas? Or do you want to just incorporate in Texas? That way everything's in one place. You really can't put it where it has. Somebody's going to sue you for patent infringement. They got to come to your backyard.
Right. And so, yeah, I mean, when you're making the structuring decision, it is important. I mean, and what you said, I think is true. I mean, do you want to defend those cases in a different jurisdiction than maybe where you live, where you really do work? How expensive is that going to be? We always tell people, yes, I mean, Delaware is, I mean, the world standard for corporation law. And it's sometimes the running joke is that Delaware corporations can do no wrong because the Chancery Court is willing to protect them, like, in the extreme. But the truth is, like, you do have to be prepared whenever you're running a Delaware corporation that someday, if somebody does sue you, that you might have to go to Wilmington, like, and defend it, and defend your case there. And so, and while I don't think that's attractive for a lot of people, I would say 99 times out of 100, I mean, I'm not sure that will ever really be the case. A lot of people run their businesses for a very long time and never get sued. And so, like, as far as a concern goes, I think that should not be at the forefront of your mind whenever you are structuring your business, but it is a factor to consider. I mean, location does matter, and actually, in many cases, especially when it comes to jury trials, like in Texas, like they do care whether you're from the area in some events. A jury is more likely to rule in favor in some cases for the guy that lives there locally and not in favor of the big bad wolf that's coming from New York or something like that.
Very true.
Yeah. But anyways, yeah. As far as selling patents, so, like, and this is the last slide for those of you listening right now. As far as selling a patent goes, like, I think in similar cases, you might be assigning the patent to that person in exchange for a set amount of money. But when you do sell it, don't you have to you have to acknowledge that with the USPTO if it is a registered patent, right? I mean, you can't really sell something that's in process, right? You can't sell something that has not obtained a registration number or certificate, right?
You can. It's when you're selling the possibility that you would have rights. You're not selling. You can't really say that you have any rights because you don't at that point.
Mm-hmm.
But you can sell that patent or license the pending application, and just license it. And a lot of times there's some type of contingent language or something along the lines of, this is predicated upon this issuing later on. Here's how the terms will change upon the issuance. Something along those lines where there's some type of benefit of the company signing it before it issues.
Right.
In terms of putting it before the patent office, license agreements are typically not disclosed to the patent office unless there's some legal reason to do that. Now, when you sell a patent, if you're signing it over to another company, which usually they'll want to do if they're buying it,
sure,
is they'll put the assignment in the assignment records of the USPTO, which
right.
are publicly available, and that also puts everyone on notice of who actually owns the patent.
Yeah. So, I mean, it's also like you're basically tracking a chain of title, correct? I mean,
Yeah.
similar to other forms of property. I mean, similar to selling a house. I mean, there's going to be in the index somewhere a record that this did change hands at one point in exchange for money. It's not disclosing the nature or the terms of the agreement. It's just disclosing that an assignment indeed did happen. And that's pretty similar to the way a trademark assignment works too. I mean, if you have a registered trademark, we assign the trademark to somebody else, and then we would register that the assignment has taken place.
Yeah.
Correct. Yeah, and I mean, like as far as selling a patent goes, like I can imagine that when it comes to selling something in process, like you said, that let's say, I mean, this company has been around for 5 to 10 years. It does have other patents, but it has a few of them that are still in the process. So what you were talking about with those agreements where, I mean, it does mention contingency language. I can imagine that a company acquiring another company would have like basically a side agreement acknowledging all of the in-process patents and saying like the value that we will pay you, like as far as these patents go with respect to the rest of the transaction is contingent upon being able to obtain them in some cases. Like we're not paying you $100,000 for something that is a maybe, but we will pay you if we do end up getting it. And
or something I've seen in terms of licensing agreements is it'll say there's a minimal licensing fee that's done till the patent issues, and then that increases by X percentage or X amount of dollars.
Right. Yeah. That's probably more of an industry standard way of doing things, right? I mean, at least you're getting something for that contract rather than just agreeing to a goose egg and hoping for the best whenever that person gets around to getting the patent completed. And I mean, to give you guys an idea, these are about all the slides we have for today. I mean, there's a lot we could talk about, like when it comes to patent law, especially when you get down into the weeds on this. And maybe that's good for another webinar sometime in the future where we do talk about more definitively, like here is everything you need to know about software patents. But if you have any questions, I want to remind you, please reach out to Andrew. His email is jareed@cclaw.com. He works for Carson's and Cahoon. He really, there it is right there. I mean, if you have any questions for me as well, I mean, my email, Kyle@JonesKertz.com. Normally, I would send out the slides at the end of the presentation. I think what I'm going to do is once I get the video from Capital Factory, I'm going to go ahead and send that out to everybody who participated, or for everybody who didn't get to see it, and for those that did attend today. But yeah, I mean, Andrew, thank you so much for joining us today.
You're
really
welcome.
appreciate it. Yeah, and I mean, you definitely are a wealth of knowledge when it comes to this. Something that I appreciate having you as a resource, and hope that I can forward you some more business sometime soon.
But hopefully be able to do the same. To help set up.
Definitely. And that's all we have for today, guys. Like I said, feel free to shoot us some questions via email or drop us a line sometimes. Other than that, that's it. Thanks, guys.
Thank you.
Take care.